Okay, welcome everybody. There are still people coming in, but we'll start with an introduction anyway. Welcome on behalf of ETIS to the webinar on how the AI Act will impact the European telecom industry. We're very happy to have Laura Jugel from the European Commission to give us a deeper insight into the AI Act. But I would like to introduce Atis first for the people who do not know us yet. I'm here with my colleagues Konrad, Ayush, and Ruxi. And basically, we're a platform in the European telecom industry organizing webinars, physical meetings, and also every year a gathering. I will give some details on the upcoming one in a second. And we also produce surveys and benchmarks. So we are already on the market for over 30 years, and we're very happy to have as members over 30 operators all over Europe, 17 suppliers in the European telecom industry, and we have in total 20 working groups. Here you see the list of working groups. All these working groups are also described on our website, etis.org. Feel free to have a look at it if you don't know us yet. But you will see a lot of the working groups definitely are impacted by AI. And it was also, by the way, the theme of our conference we had this year in June in Prague, how AI will impact the European telecom industry. So we're very happy to have a deeper dive on it during this webinar. We will record this session so you can have a look at it via YouTube later on. We will send you also the link after the webinar. We would like you to ask questions via the chat function. We are quite numerous in this webinar. We have around 300 registrations, so it is very difficult to take the questions live during the webinar. But if you ask them via the chat function, we may already take some questions during the webinar, and we also have time at the end of the presentation also for a Q&A. We will also circulate the presentation after the webinar, so no need to take pictures or notes of these slides. You will get them after the webinar. So without further ado, I want to present Laura Jugel, who is Legal and Policy Officer at the European Commission. And she will guide us through the AI Act and what is in it and what is not in it. So, Laura, the floor is yours. I will come back with some upcoming activities and also a short survey after the webinar as well. So, Laura, the floor is yours.
Thank you, Wim. Thank you very much. I hope that you can see my slideshow well now.
Yes, we can.
Fantastic. Thank you. Thanks a lot for inviting me and for organizing this webinar. I have already been introduced. I work in the European Commission, and concretely, I work in the European AI Office. So that is an office that has been established within the European Commission. We are responsible for AI policy in general. So we are responsible for the AI Act, the new AI Act that has entered into force earlier this year, and the way it's implemented and applied in Europe, and to coordinate this and guide it and support it. But we are also responsible for innovation policy in AI and for our international cooperation in that field. And I want to emphasize this so much because I want to highlight that the European Commission pursues two objectives when it comes to AI. We want to foster excellence. We want that AI is used, that we harness this emerging technology and all the benefits it can bring for our society. And we want to ensure that it is trustworthy because we think this is an essential element of making sure that AI will be actually used and support our competitiveness. And for that reason, in 2021, so already a while ago, the Commission presented a proposal for an AI Act. So always with the objective in mind to make sure that AI in Europe is trustworthy, so that in the long run it will be taken up and used in many products, in many fields, in many sectors. This AI Act has been negotiated for several years between the EU legislators, the member states on the one hand, and the European Parliament on the other side. And they reached an agreement earlier this year, and now the AI Act is in force and will start to apply over the course of the next 2 to 3 years. So introducing the AI Act, what is there to know? We have 5 things that I think are fundamental basics to understand a bit how the AI Act works. First of all, the AI Act is a product safety regulation. This means what the AI Act does is to introduce rules for how AI can be put on the EU market and used in the internal market. So there are certain requirements that AI systems as products have to fulfill, certain applications of those, not all of them, in order to be able to be marketed in Europe. The reason for that, and that is also the second basic to know about the AI Act, is that it should be complementary with other EU law. AI systems, AI is a technology that's not just used for standalone software solutions, but implemented into many different kind of products and processes. And many of these products, these processes, these sectors already have regulation in place, often even product safety regulation. And to the extent that AI is integrated, we want to make sure that this AI is safe. And therefore, we have also chosen this product safety regulation to ensure coherence. I said it already, we focus on the AI system, the product that's put on the market. That's the third basic. Why this is important is because it's a technology neutral approach. We define what is an AI system in the AI Act, and the AI Act keeps this open and broad. It will be defined in guidelines even more clearly, so that in the future updates can be quickly done as the technology emerges and evolves. Fourth, the AI Act is innovation friendly. I said it, we have these two objectives. We want to foster both excellence and trust. And the AI Act, it works on the assumption that AI is a positive technology that we want our industrial sectors, our public administration to adopt into their products and services. And so therefore we follow a risk-based approach. We only regulate as much as is necessary. We introduce rules commensurate to the possible risk that can be brought about with the use of AI. And in this vein of trying to be innovation friendly, we also introduce in the AI Act certain tools that we hope will also foster innovation furthermore, which is, for example, AI regulatory sandboxes or the possibility to test high-risk AI systems in real-world conditions. And then finally, very closely linked, the risk-based approach. That is the fundamental approach we take with the AI Act. I have already mentioned it, and I will now go into more detail about what this means in practice. So what do we mean by saying we follow a risk-based approach with the rules? We have defined more or less 4 risk categories and of possible risks that the use of AI can pose for health, safety, and fundamental rights. These are the protected interests of the AI Act in principle. You can see with the pyramid, we start at the very top. The smallest amount of AI systems will fall under the category of AI that poses unacceptable risks and therefore should be and will be prohibited by the AI Act. This is a very targeted number of applications. I'll say a bit more in a moment. But for example, this includes social scoring or individual predictive policing. The core of the AI Act, though not the largest category of these four, are AI systems that are expected or could possibly pose a high risk to health, safety, and fundamental rights. I will tell you more about when AI systems are deemed as high risk, but to give you already some examples, that is, for example, AI that's used in recruitment to select applicants, or that is AI that is used in certain medical devices to ensure these are safe. If these AI systems do not function well, there could possibly be risks to health, safety, and fundamental rights, and therefore these AI systems should meet certain requirements to make sure they are safe and trustworthy. Then we have a category that we always label transparency risk. What is meant is these are AI systems where it's particularly important to disclose that AI is used in order to ensure that people trust the use of AI more broadly. For example, if AI impersonates real humans, chatbots, for instance, or voice assistants, like when you call a hotline and in that hotline you do not speak with a real person but with an AI-based voice assistant. In these cases, humans should be informed that they are not interacting with another human but with a machine. The same applies, for example, when AI is used to generate contents. In certain cases, humans should be informed that the content that they see is not real but is synthetic, so that they know and will be able to trust contents that they come across in the future. So for this risk category, we introduce disclosure obligations, for example, labeling or the so-called watermarking, but I will say a bit more in a few moments. And then lastly, we have the biggest category. We estimated at the time that we prepared the AI Act proposal in the European Commission that this would be around 80 or even more of the AI systems that are already in use in Europe. These are AI systems that pose minimal or no risk, and therefore they do not. There will be no further restrictions or any new rules under the AI Act. That doesn't mean that no rules apply. For example, if these AI systems process personal data, then the GDPR, the General Data Protection Regulation, may apply, but the AI Act does not introduce any new rules. So that's the approach we've taken. That's the approach that we thought would be very proportionate. Introduce rules only there where it's necessary, and otherwise give space to use AI as is needed in order to innovate and improve processes and efficiencies. To give you a bit more details about each of these categories, I want to start with the prohibitions, the unacceptable AI practices that will be banned. The idea here is to not only ban these problematic applications that we see can pose unacceptable risks, but also to really clearly establish what are AI practices that we want or do not want in Europe because they contravene our EU values. And we as the Commission, we have proposed certain prohibitions, and this, what you can see here is the final list that was discussed by the Member States and the European Parliament. These are 7 categories, so to say, starting with AI-based manipulation or exploitation of vulnerabilities in a way that can cause harm. So, for instance, if subliminal techniques are used in AI systems to push people to a certain behavior that is harmful to them and that they would have not done, would they have not received these subliminal cues. Social scoring for public and private purposes. You all know the examples of social scoring in China. So this was decided is practices that we do not want in the European Union. Biometric categorization, when it is used to infer or deduce from biometric data, so data about features of a person, the race or political opinions or religion or sexual orientation. Then real-time remote biometric identification. That is one that you may have read about a lot in the press, because that has been one of the most controversial points in the negotiations of the AI Act. Remote biometric identification, that is, for example, facial recognition. If this is applied in real time by law enforcement, this is, of course, quite intrusive and will be in the future now prohibited, with very narrow exceptions in case this is needed for public security purposes, to fight terrorism or to search for missing persons. Individual predictive policing, so when profiling is used to make assessments if someone may have committed a crime, and based solely on this profiling, decisions are taken about a person. Emotion recognition in the workplace and education institutions. That's, for example, AI systems that measure if someone working in customer service is friendly, and then helping the employer to make decisions about the person on that basis. And then finally, untargeted scraping of facial data from the internet in order to build databases. You all probably have heard of the case of Clearview AI, which is a company from the US that has used AI to scrape social media and build databases that are also then later used by law enforcement. So this is a bit one of the examples of what this prohibition is trying to limit in the future. So that's it for the prohibitions that the AI Act will bring about. Now I want to talk about what I said was the core of the AI Act, the high-risk category, the category for which most of the rules are actually put in place. The AI Act classifies AI systems as high risk in two ways. On the one hand, this goes back a bit to what I said, AI being used in many different kinds of sectors and products. AI will be classified, or can be classified, as high risk if it's embedded into a regulated product, or even makes up such a regulated product. This doesn't apply to all regulated products. In fact, the AI Act has an annex with 22 pieces of legislation, EU legislation, for which this is the case. I listed some examples on the slides. So the machinery regulation, radio equipment directive, toy safety regulation. Others are medical device regulation, marine equipment or pressure equipment. So product safety legislations. And in case an AI system is intended to be used as a safety component, so fulfills a physical safety function for any of these products, or if an AI system itself is a product under one of these regulations. This could be, for example, the case for medical devices, where certain AI-based software applications are classified as high risk. Then that AI system is high risk also under the AI Act and needs to comply with the AI Act technical requirements. And those who put these AI systems on the market must must undertake a conformity assessment and have certain obligations. So that's one large part of when AI systems can be deemed high risk and when they will be met with certain requirements under the AI Act. The other pillar, so to say, of the high-risk classification are AI systems that are used in so-called high-risk use cases. For this, we also have an annex that lists 8 areas that are deemed very sensitive for health, safety, and fundamental rights. These areas are, for example, law enforcement, the justice sector, migration, but also critical infrastructure. And for each of these 8 areas, the AI Act in this annex lists certain use cases. And if an AI system is intended to be used for one of these use cases, so it's marketed for this purpose, then it will classify as high risk. So to give you a very concrete example, one of these areas, the 8 areas I talked about, is also recruitment. But not any AI that's used in recruitment or in human resources will be deemed high risk. Only if it fulfills one of the use cases. One of these use cases is, for example, AI systems used to filter job applications. So an AI system that is maybe used to handle documents in recruitment will not be high risk, but an AI system that is intended to be used to select applicants or make proposals on how applicants should be selected, that will be then high risk. We also have a so-called filter, even if AI systems fall under this Annex 3 and under one of these use cases, they could still be excluded from being high risk. This tries to take into account that some of these formulations, because they are law, are quite abstract, and in practice, maybe there can be cases where the AI system falls under the category but doesn't actually pose very high risks. And the AI Act lists a couple of these exceptions from being high risk. For example, if the AI system performs only a narrow procedural task. So to stick with this recruitment example, we have an AI system that helps in the selection of applicants, but in reality, what it does is only to take the incoming applications and separate and label, this is the motivational letter, this is the CV, and these are the substantiating documents that the applicant has submitted. Then this is a narrow procedural task, and the AI system doesn't need to be deemed high risk. Now, this is how the AI high-risk classification works in practice. What, of course, many of you will be wondering about now is what kind of AI applications could be deemed high-risk in the telecom sector. And for this, there is one specific high-risk use case. It's in this second pillar I was talking about, so in Annex 3, self-standing AI systems, so to say, not those integrated into other products. And this use case is AI systems used as safety components in the management and operation of critical digital infrastructure. The full use case is what you see here in bold. Relevant for you is the digital infrastructure here. It's digital infrastructure as it is defined also in the Critical Entities Resilience Directive. For those of you who are familiar with that, so it is not any digital infrastructure, but there is an annex to this other piece of legislation, the Critical Entities Resilience Directive, that really clearly establishes which of the digital infrastructure is deemed critical. But telecoms can fall under this annex, under this definition of critical digital infrastructure. So therefore, this use case may be relevant for you. And what I want to really emphasize is this covers only AI systems that are used as safety components. What does it mean? It means only where this AI system is used to directly protect the physical integrity or health and safety of persons, physical integrity of the infrastructure or health and safety of persons involved in the operation of the infrastructure. The AI Act even gives an example for this. So it's AI-based fire alarm controlling systems in cloud computing centers. So it's really quite a targeted use case. And I think the work that we will be doing now as the European Commission, we are preparing guidelines on all of these high-risk use cases. And we will try to define very clearly, and this is where hopefully we can be in exchange with you to find the use cases that should be affected and the use cases that should be out of the scope. What we aim to do is define very clearly and provide guidelines on how this should be interpreted and what is in the scope and what is out of this narrow use case. That's for the ones that are specific to the telecom sector, but then of course companies per se can be more broadly impacted because other use cases can be or other uses of AI that are a bit more horizontal, not telecom specific, but many organizations use can be affected by the AI Act and the high-risk classification. I have already talked quite a lot about the example of human resources. That is, of course, the most obvious candidate AI-based recruitment systems that help to evaluate applications. They will be deemed high risk. So that is something that affects many organizations in this process management. And then we also have the transparency rules later on for chatbots, for example. That is often the case for customer service, something that I know that many of you are also maybe possibly using, but these would then not be high risk. For the high risk, it's mostly these use cases, the safety component of digital infrastructure and the field of human resources that will be relevant for you. Now we know what is high risk, but what does it mean actually if AI systems are deemed high risk? What are the requirements? What are the obligations? We need to distinguish here between those who are providers of high-risk AI systems, so those who develop these solutions and put them on the market, and those who deploy them in practice, so the companies who may buy this solution of the provider and implement it into their own processes. The biggest part of the regulatory burden, so to say, lies with the providers because they are the ones to develop the solution and they are responsible and can influence how the technology is shaped. So they must make sure that these AI systems meet certain requirements to ensure they are safe and trustworthy. The AI Act sets out a couple of technical requirements that relate to data governance, the possibility to maintain human oversight, the accuracy of this high-risk AI system, the robustness against cyber attacks, for example. All of these requirements, we are developing for them harmonized standards. This is an ongoing process. I will talk about it a bit more later, but I want to already flag it here. So ideally, in the future, anyone who develops AI systems, high-risk AI systems, can follow these harmonized standards and then therefore trust that the AI system will be in conformity with the AI Act. The providers not only need to ensure that these AI systems meet the high-risk AI Act requirements, but they also must make a conformity assessment before placing the system on the market, which hopefully will be facilitated then in the future by the standards. Depending on for what reason the AI system is deemed high risk, this conformity assessment would be either done as a self-assessment. That's the case for most of these annex-free self-standing AI systems, or by a third party, and there will be certification bodies for this in the future. That is the case for AI systems that are integrated into already regulated products. Most of them need to undergo a third-party conformity assessment. And then later on, when the product is already on the market, these providers are also in charge of doing a certain post-market monitoring, looking out for incidents, ensuring quality and continued risk management to minimize the risk for deployers and affected persons. And all of the high-risk AI systems in the future must be stored in an EU database that is accessible to the public, to the authorities, but also to the deployers who want to use high-risk AI systems and buy them, where they can find a minimum of information, contact details, the intended purpose of the high-risk AI system. So that's that for the providers. The deployers, as I said, they have less obligations, but they also have certain obligations. First of all, they need to correctly use the high-risk AI system in accordance with the instructions of use. That is something that applies for any product. In all product safety legislations, providers must make instructions of use of how a product should be used, and then the deployers should use it accordingly. They also have to make sure that the employees who work with the high-risk AI system are well trained and are able to exercise human oversight, that representative data is used when these high-risk AI systems are used, and that logs of the use are kept for a certain amount of time. Then there are certain possible obligations depending on the use case, depending on who is the deployer. For instance, information obligations vis-a-vis affected persons. That is the case if the high-risk AI system is used to make decisions. So always with the example of the recruitment, a person about whose application a decision is made using a high-risk AI system should be informed of this circumstance. There can be cases in which deployers must make a fundamental rights impact assessment. This applies not to all deployers horizontally, mostly to the public sector and in the field of creditworthiness and health and life insurance. So not for the human resource use case, for example, not for the digital infrastructure use case, but to these other entities. And then the public sector always also has to register the deployment of high-risk AI in the EU database that I spoke about for providers. So that is for the public sector only. So this was to give you a bit of an overview of the requirements and obligations. As I said, this is really the core of the rules that we introduced with the AI Act, the largest chunk. I have already spoken briefly about the transparency risk category. Here, the obligations that come are a bit more light touch in comparison to the high risk requirements and obligations. They are mostly disclosure obligations. They could be relevant because chatbots, AI-based chatbots, are used more and more in customer services, so they could be relevant also for the telecom sector. The disclosure obligations apply when interacting with an AI, so the chatbot must inform the human user that the interaction is with an AI and not with a human, unless this is already obvious from the circumstances. And then I also mentioned already the obligation to inform humans if decisions are made about them involving the use of an AI system that is high risk, so in recruitment, for example. And then for generative AI, there are certain obligations. Those who provide generative AI systems, so who develop them and put them on the market, need to make sure that the output of that system, so the synthetic AI generated content, is marked in a machine readable way. There are different technical solutions for this. For example, watermarking is the most known technique to ensure that then later using machines, AI content can be detected as AI generated content. And certain AI generated output also needs to be visibly labeled, deepfakes and text that is intended to inform the public on matters of public interest. Then we have one chunk of obligations that I have not spoken about so far at all. I told you in the beginning that we focus only on AI systems. There is one exception to this rule, and that is general purpose AI models. These are general purpose AI models. That's the AI Act term to capture foundation models, large language models. So these highly AI capable AI models that are used at the basis of many generative AI systems, for example, ChatGPT. So here we break with this logic of focusing only on the AI system, but focus for once on the underlying technology. And the reason for that is that these models are so highly capable that, first of all, we need to ensure that developers who use these general purpose AI models to develop AI systems as final products have all the knowledge and understand all the capabilities of these models to develop AI systems safely. So there must be a certain transparency along the value chain. And then, because of these capabilities, there can also be systemic risks. Think, for example, disinformation. That can be one of the risks that follows. AI content can be generated in highly large volumes, very authentically seeming. So these possible systemic risks have to be mitigated as well for certain of these general purpose AI models. We have a two-tier approach, so to say, and this second layer of obligations, the risk management, applies only to the models of highest capability, measured on the basis of a technical threshold of compute. And there, these additional obligations come in. We are right now detailing these rules in the context of a code of practice. You may have heard about this. It's a code of practice that should explain how providers in the future can comply with these rules for general purpose AI models. I wanted to mention this to give a bit of a complete picture, but this will apply, of course, to a very targeted group of companies in the future, namely those who develop these general purpose AI models. So I have spoken about the rules a lot. Now you have a picture a bit of what kind of rules will come. The question is who will enforce them, who will oversee them? Because the AI Act is a product safety regulation and applies in coherence with all of the other product legislations I've mentioned already, medical device, machinery, toy safety, and so on. We follow the same approach for the AI Act as we follow for these pieces of legislation, and we apply the market surveillance regulation. So this means that the oversight takes place on national level. There will be authorities in all EU member states, on the one hand, who will oversee the establishment of certification bodies, so that before a high-risk AI system is put on the market, providers have someone to address for possible third-party conformity assessment, and also market surveillance authorities who monitor that AI systems are safe, who intervene in case of incidents, who are also contact points for possible complaints about possible violations of the AI Act. So these are all going to be established. The timeline for this is summer next year. So the discussions are ongoing in the EU member states as who should be these supervisors. For AI that's integrated into already regulated products, the regulators in these different pieces of legislations will remain responsible, and they will now then need to also supervise the AI part. So it will be quite a comprehensive system, and we are working with the EU member states that they find a way to establish this in a streamlined manner, in a well-coordinated way. For the general purpose AI models, those I spoke about last, the oversight will take place on EU level because this addresses only a small number of developers right now, and it's quite a novel technology, so there it was decided it would make most sense to centralize the oversight. And for this purpose, we have established the AI office also. As you know, I mentioned in the beginning of my presentation that I work for the AI office. Here we will be the regulators of these kind of highly powerful AI models. But we in the AI Act think governance more comprehensively than just authorities to supervise and enforce. We also include the stakeholder community, the scientific community, and therefore we have 3 advisory bodies that are currently being established. First of all, the AI board, where the member states come together to discuss and ensure the coherent application of the AI Act all throughout the European Union in all member states. So there are going to be a lot of groups where the different authorities can come together and discuss how they apply the AI Act, how they understand it. Also ensure that the guidelines we prepare now in the AI office, implementing the delegated acts, are well coordinated across all EU member states. Then we have a scientific panel that is our link to the scientific community. It will be a group of independent experts who will provide the AI office and the member states with independent technical advice in the implementation. And also when we take decisions about keeping the AI Act up to date, when we modify certain parts of it, they will be consulted. And then lastly, we have an advisory forum, which is a group where civil society, academia, and industry can come together. The AI Act says it should be balanced in terms of commercial and non-commercial interests, and there will also be the standardization bodies involved. So this is where general input can be sought for all the decision-making going forward. So where do we stand? What are the next steps? I've said it already, the AI Act has been adopted earlier this year. It's entered into force in August. That doesn't mean it already applies. It will actually apply in a sort of staged way, starting with the prohibitions February next year. Then the governance I mentioned must be in place already in August next year, and the rules for general purpose AI models will already start to apply. All other rules in principle apply in August 2026. So that is the rules for high risk, transparency rules. By then also the AI regulatory sandboxes I spoke about will have to be established, with one exception, and that is high risk AI. That is high risk because it's embedded in already regulated products there, because the certification procedures are already in place and will now have to integrate AI. The authorities are already in place and they will now have to build up expertise in AI. The AI Act gives them a bit more time to adapt these procedures. We in the AI office and the European Commission, we are right now working very closely with the member states in establishing these governance bodies and also the advisory groups. The AI board is already established, the scientific panel. We are taking the concrete steps right now, and the advisory forum will follow early next year. We are also doing a lot of work on detailing how the rules should be applied in practice for the general purpose AI model rules, because they apply already next year. This work is ongoing. We are drawing up a code of practice, or we're coordinating this exercise. It's drawn up by the stakeholders, both developers, downstream industry, and civil society and academia. I mentioned that for the high-risk requirements, there will be harmonized standards. We have given the mandate to develop these standards to CEN and CENELEC. That is something that we follow very closely, where we try to get industry and stakeholders more broadly to engage as much as possible. My colleagues follow all of the working group meetings to make sure that this work is progressing well. And then we prepare guidelines, we prepare implementing and delegated acts. And I have mentioned already, we are preparing guidelines on the high-risk classification, and we will launch early next year stakeholder consultations. And this is where will be seeking your input and are looking forward to work with you closely to make sure that this is a practical guidance document that helps you very well in the preparation for the application of the AI Act in the future. And I have mentioned most of our initiatives already, but I want to take one very quick last moment before we go into the Q&A part to highlight really how we are trying to support as much as possible compliance and work with the stakeholders that will be affected by the AI Act in the future. We have one initiative that is quite innovative. It's the so-called AI Pact. Maybe some of you are already participants to this. We have launched this earlier this year. It's basically a network. It says on the slide 1,300 organizations have joined. This is not true. My colleagues have told me this morning it's actually 1,400. We're trying to create a network of everyone who is interested and would like to prepare early on for the application of the AI Act. We will have webinars and workshops where we explain more different parts of the AI Act and how the preparation can take place. And we also encourage the anticipated application of the AI Act, and we actually have provided the opportunity to sign voluntary pledges to anticipate certain key provisions, for example, related to governance and AI literacy. And to date, we have more than 130 signatories. And for those who sign up and commit these voluntary pledges, we also provide platforms for exchange of best practices and try to really have this regulatory dialogue. I spoke about the standards, so I will not say more about that. But this is an ongoing work that is very, very important to facilitate the compliance with the AI Act in the future. And we are leveraging the programs that we have on EU level, the Digital Europe program, for example, to develop support actions to support compliance very concretely. For example, we are currently setting up a so-called AI innovation accelerator that will provide materials and training courses and digital tools that help to guide the classification of AI systems as high risk, or to find out if an AI or if a software solution classifies as AI under our AI system definition or not. And with this, I close because I want to leave room for questions. I've already spoken so much. Thank you very much for your attention so far, and I look forward to discuss with you now.
Okay, thank you, Laura, for a very clear and insightful introduction to the AI Act. We already have a lot of questions, going from very specific ones on emotion recognition, the impact on cybersecurity activities and logging requirements, to very generic ones. And perhaps I can start with the generic one because I think it will apply to everybody. Of course, there is a debate going on in Europe whether the AI Act will stifle innovation or accelerate innovation. And also in the Draghi report, which was published in September, there were some remarks about complexity and inconsistencies in the AI Act, which could undermine possibly innovation. You also referred to the situation in China, where the regulation is a lot looser. Also with what happened last week in the US and the upcoming new administration. It is unclear what the regulation will look like in Europe. So, how can we make sure that we balance regulation and innovation also in Europe? We're not doing that great in AI companies so far. How will the AI Act accelerate innovation, in your opinion?
Thank you. So we have tried to design the AI Act in an innovation-friendly way. The most important and fundamental choice for this is the risk-based approach. So it's a horizontal regulation because it doesn't apply to just one sector, but it doesn't apply to all AI systems in the same way. It applies only to the most of the rules are introduced only for certain applications that can pose high risk. We also use certain instruments like standards and the code of practice to detail out the rules in more detail and in dialogue with those who will apply the rules in the future to make sure they are workable in practice, which I think is also an important dimension. Then we have the tools I spoke about that try to even foster innovation more concretely, like AI regulatory sandboxes and the real-world testing. And as for the complexity, this is now our job to make sure that we detail these rules in a way that they are clear, that we provide legal certainty. I think if we didn't have the AI Act, there would be a very high probability that we would have 27 different AI acts in 27 different member states. So the idea was also to create one harmonized set of rules so that there's a predictability of what comes. And let's not forget there are certain risks, and that's why there would be such a likelihood that that member states would choose to have their own sets of rules. And there is public concern. There are questions that people have when it comes to AI. So having an AI Act that sets out a basic set of rules and fosters trust and acceptance is also important to encourage that AI is actually adopted in the public sector, in companies, that the broader public accepts that we use AI more and more. And then you have mentioned the international context. Of course, different jurisdictions take different approaches. With the US, for example, we have very different legislative traditions. In Europe, we are always maybe a bit more cautious ex ante. We ask certain requirements, but then later on, the liability doesn't compare to the liabilities that you can face in the US when things go wrong. Now, we all know these famous damages claims that there are, and we see we've started very early in the EU with the rules that we have put forward as the European Commission and the discussions we've had with the legislators. But we are not isolated in this. In fact, many are looking now at what the EU has done and taking this as a blueprint. We see this in Brazil, in Australia, in Canada, the US, while the Trump administration has been quite vocal about not wanting to regulate very much. We see that some of the states have already taken action and looked also at what the EU has done and taken inspiration from that. Colorado was the first one, but you may have read in the press over summer the discussions in California, where all of the big tech companies are, and where the Californian legislature has also taken quite strong action. So we can see, I think what's important is that the AI Act will apply to anyone who puts AI systems on the market in Europe or whose AI will be used in Europe. So it will create a level playing field also with companies from outside the EU, because if they want to access the EU market, they must play by our rules.
Yeah. Okay, very clear. Thank you. Perhaps some more precise and direct questions related to more detailed interpretation. First question is related to the emotion recognition, which you mentioned is prohibited. The question is if it is only prohibited if the emotion is inferred through biometric data, or is it prohibited at all? I think some chatbots deal with emotion recognition, for instance, but what exactly is meant in the legislation?
Very good question. Actually, this is a peculiar or an important case. For emotion recognition, we have three sets of rules. Maybe that is important to mention these risk categories. You know, the pyramid I've shown you, the categories are not necessarily mutually exclusive. The prohibitions, yes, but the rest, no. So for emotion recognition per se, the way it's defined in the AI Act is when emotions are inferred from biometric data. So that's already scoping it. And in principle, whenever emotion recognitions are developed, they will be deemed high risk. So they have to comply with the high risk requirements that I spoke about related to governance, data governance, and using representative data to avoid that they have a bias, for example, human oversight, accuracy, and robustness. So any emotional recognition system within the scope of the AI Act is high risk. And there is also the obligation to be transparent about the use. So if persons are subject to the use of emotional recognition, they must be informed in the future. And then there is the specific case of emotional recognition at the workplace or in education institutions. And this will be prohibited. Only these two applications, so not emotion recognition broadly, but when emotion recognition is deployed at the workplace or in education institutions. The idea here is that these contexts of power asymmetry, where employees or students are particularly vulnerable, and the use of emotion recognition can be particularly intrusive, and therefore the legislators have decided to prohibit it in these circumstances, but otherwise not. And for the case of emotional recognition at the workplace, I also have to mention that there is an exception to this prohibition, and that is if this emotional recognition is used for safety reasons. So think of the most famous use case in this is emotional recognition that tries to detect signs of someone being sleepy, a truck driver, for example, being sleepy, and then in the instance, this emotional recognition system detects this, alerting that truck driver and flagging that the person should take a break, for example. So that is a case that will be exempted from the prohibition. So I hope this covers
Yeah.
it. It's quite a peculiar case, emotional recognition.
Yeah, thank you. There are several questions related to the safety components and the exemption for safety components in critical digital infrastructure, of course, very appropriate for the telecom industry. And so there are questions whether only safety systems are covered or also security related systems. For instance, does it cover AI use in cybersecurity tools covering critical infrastructure? The
So
exemption.
yeah, the safety component, it's something that's defined in the AI Act, and you have to think of it. We try to have the safety component as a bit of a filter. So not any AI system in the critical digital infrastructure would be deemed high risk, but only the safety components that fulfill a safety function. And if they don't function well, there could be a risk to health and safety for people. That's the logic behind it. And the way it's defined, it links to safety as in physical safety of the infrastructure itself, as well as of the persons, of humans. And therefore, security and cybersecurity is not intended to be covered. So AI systems that fulfill certain security functions are intended to keep to preserve cybersecurity would not be deemed high-risk AI systems under the AI Act.
Okay. Perhaps a last question because we're almost at the end of the foreseen timing. Um, a detailed question related to the logs which need to be
Mhm.
provided. How long do the logs need to be kept for deployers of high-risk AI systems?
So this is in Article 26 of the AI Act, and I'm just cross-checking that I do not give you the wrong information, but I believe it's 6 months. Yes, 6 months. So this is in Article 26, paragraph 6 of the AI Act. And so deployers of high-risk AI systems, they need to keep logs. The providers, this is something I haven't mentioned, but the providers, one of the technical requirements that they have is that the AI system must be designed to create logs automatically, and then the providers, the deployers need to store them for a duration of 6 months.
Okay, very clear. There are some other questions, but what I would propose is that we send them to you, Laura, and that we reply to them offline. You can also send more questions via the chat or via mail to us if you have burning questions, which cannot wait. So I would like to thank again Laura for the very inspiring presentation. Of course, 1 hour is very short in order to give all the details related to the AI Act, but I think it was a very structured presentation. So thanks again for that. And I already would like to invite Laura to an upcoming event, which I want to already announce now. We will have on the 5th and 6th of June next year in Athens our yearly community gathering. So most of our working groups will meet in Athens those 2 days. AI, of course, will be a very important topic. It was already the major theme of the one we had in Prague in June this year. But it's clear that it's still in its infancy, the AI technology. So we will continue also to see how it can help to enter other verticals for telecom operators. So a warm welcome to all of you in the call to already save the date. You will also get an invitation at the end of the week officially. And I also would like to ask you before leaving now to take a shot of the QR code now shown on your screen so that you can provide your feedback to us. It's always important to see what you liked, what you think we can improve upon in our webinars. So if you can take the survey, it will only take 1 minute of your time. This would be very much appreciated. So I would like all of you, or to thank all of you for attending the webinar. Again, a warm thank you also to Laura and also to the people of the central office who helped to organize this webinar. Konrad, Ayush, and Rupsi. And see you in a future webinar. Don't hesitate to look at our website, etis.org, to see upcoming activities. Enjoy lunch and see all of you soon in an upcoming activity. Bye-bye.
Thank you. Goodbye.
Thank you, everyone. Thank you, Laura.